In this short presentation, I'm going to be talking about the General Data Protection Regulation, GDPR, and the impact of GDPR on the taking and using of photographs of children in the early years. This training covers childminders, nurseries, preschools, and anyone in the early years who takes photos of children. GDPR is EU legislation which we have been told will be kept after Brexit and which will be in place from the 25th of May 2018. We must be anticipatory. We must be ready for GDPR. There's a wealth of information out there about GDPR. I've written a series of blogs to help you prepare your data audit and your privacy notice, and Childcare.co.uk are sharing in their free childminder paperwork a lot of documents which will help you to comply. These are relevant to childminders, nurseries, preschools, before and after school clubs, all early years. I've also shared information about the requirement to keep paying the Information Commissioner's Office. It's £35 if you pay annually by direct debit. The same way we pay Ofsted. Exactly the same principles apply there. However, the messages I'm receiving seem to be mostly around the taking and using of photos, which is why I thought this presentation might be useful. Before writing this presentation, I have spoken to the Information Commissioner's Office at some length about early years providers and photos, and this presentation is the result of our conversations. However, if any areas of practice remain unclear, the best thing to do is to call them and talk to them. And you have their phone number here. Before we talk about photos, specifically about photos, I just want to look quickly at the principles, rights for individuals, and lawful bases noted in GDPR, just so we've got it clear in our heads. And I'm doing this on a video so that you can look back at it. What was she saying about this? Oh yes, I'll just go and have a quick look. Under GDPR, and remember GDPR is an EU law that covers every single one of us. It covers our data, our children's data, our neighbours' data. There are 6 principles. Data processing must be fair and lawful. You must have a purpose for processing data. You can't just collect extraneous bits of information, just in case. Your data must be adequate for its needs, not too much, enough to allow you to do what you need to do. Data must be accurate. You must consider how long you keep, how long you retain data. And every individual, including you and me, our children, your children, and childminded children, nursery children, parents, everyone has the right to confidentiality. The principles of GDPR I'm going to be focusing on in this presentation for the purpose of photographs are purpose limitations, the purpose for processing data, data retention, and the rights of the individuals. And you'll see those in red. There are 8 rights for individuals under GDPR, and you can see them listed here. We have a right to be informed about what data is held about us, and that includes what data we hold about the children and families who are working with us at the time. We have a right of access, and parents and children, when they get older, have a right of access to their data. We have a right to rectify data, rectification, to check if something is wrong. We have a right to say, no, that's about us and it's wrong. There is a right to erasure, and that's quite a tricky one, which we'll be talking about in a little while in more detail. There's a right to restrict the processing of data. You can say, no, I don't want you to use my data for that purpose. The right to move data, the right to portability, is very important if you're thinking about how often you're asking parents to repeat the same information over and over again, and whether you can make it easier for them. There is a right to object to having your data used. And the final one is in relation to automated decision making and profiling, which is highly unlikely to be used by early years providers. The rights we'll be focusing on in this presentation, specifically related to photos, are the right to be informed, the right of erasure, the right to restrict what happens to photos, and the parent's right to object to what we're doing. When we're deciding what we can and cannot do under GDPR, and I'm getting a lot of these sort of questions, can I do this? Can I still take this out with me? Can I still check this data with parents? When we're thinking about this, there are 6 lawful bases for processing data. This means there are 6 lawful reasons for collecting information. And it's important that we know these just generally, and that we understand when we might use them. For example, there's consent. We've always had permission forms, haven't we? We've always said to parents, I'm asking your consent, I'm asking your permission to do this. However, consent is the weakest of the 6 legal bases, because parents can withdraw their consent at any time and they must be informed that they can do that. So ICO advise that consent is the one we use the least. Contractual necessity, very strong. The data processing is necessary for the contract. For example, you're required by the local authority to ask parents to complete their funding form. If the funding form isn't completed, you can't apply for the child's funding. That would be contract or contractual necessity. Legal obligation is very strong as well. That's if something's required by the EYFS or the Childcare Register or by Ofsted in the Early Years Inspection Handbook. If they require it, it's a legal obligation to do it. We collect it, we do it. Vital interests is an interesting one. It covers data that protects the child in a life or death situation. You must be able to justify when you use vital interests. For example, you can ask parents for information about their child's religion on your emergency contact form. However, it should be an opt-in. If parents want to answer that question because it's important to them, then they can do it, but they can also opt out. It can be optional. They can choose to say, no, I don't want to tell you that. Legitimate interest there is the most flexible of the legal basis for processing data. Public interest we won't need. That's relevant to local authorities. So legitimate interest is the most flexible. Again, we need a good reason for processing data, and it should be used as reasonably expected, and those are ICO's words, reasonably expected, to provide a high quality service. For example, we ask parents, don't we, about their child's home life, their daily routines, their family relationships, because it's reasonably expected we would need that information to provide the service we do. The legal basis I'm going to be talking about in relation to photos are consent and legitimate interest. Right, let's move on to photos now. You'll notice this photo is copyright Shutterstock, which means that I have had a Shutterstock account. I've been able to download this photo and use it as long as I add the copyright to it. There are different types of photos, different types of photo processing, which early years providers might want to do. And I'm going to be using these 5 examples as I move through the next 3 slides. We might want to take photos to record children's learning and development during their time in the setting. We might want to put photos on the wall. We were having a conversation about this yesterday at playgroup. Childminder said, it's important to me that the children's photos are on the wall to give them a sense of belonging. You might want to share learning and development information with parents through photos. There are lots of ways of sharing this information. Photos is just one of them. You might say to parents, I'd like to take a photo of the group of children on a picnic we've been on, and I'd like to use that on my website because I think it'll be lovely for advertising. Or it might just be a nice photo. Sometimes we do get really lovely photos or lovely photo opportunities, don't we? And we just want to take them. Under GDPR, you need to think about why you're processing data, why you're processing these photos. Using the same 5 examples, the first example, the photos will be taken to record children's learning. They'll often be printed and they'll be placed in the child's learning journey file, their learning, whatever you call it, file, which goes home with the child when the child leaves the setting or when the child starts school, whichever's sooner. In the second example, you're taking a photo and popping it on your notice board or a birthday display or in an album, which the children look through regularly. Oh, look where we went, look what we did. Do we remember this? In the third example, you might send photos to parents by WhatsApp or on a secure Facebook page or by email to say, look at what your child's been doing today. Haven't they had a wonderful time? And aren't I an amazing childminder or nursery doing all these things with your child? If you spot a photo opportunity, you might use it to pop it onto your website. You might think that's a wonderful way of advertising me and my service to future parents. Or again, it might just be a nice photo or a nice group shot. For your data audit, which you will need to do as part of GDPR, you also need to consider where these photos are stored. And this will be part of your mobile phone and camera policy, which is a statutory requirement in the EYFS. So you'll need to think about where they're stored, how long they're stored for, and things like that. Now we come back to that legal basis. Do you remember the slide we just looked at with the 6 legal basis under GDPR? What is your legal basis for taking photos of children? And this is the most important bit. And it's important we get this bit clear in our heads. ICO advice is that there are probably 2 main legal bases for taking photos of children. And these are legitimate interest and consent. Using the same 5 examples again. Photos taken to record learning and development. The legal basis is probably legitimate interest, because you're prepared to argue, if you're asked, that the processing of these photos is necessary for you to do your job, for you to do your job effectively, for you to do your job well, and to allow you to show evidence of your activities to Ofsted in an album, for example, the child's learning and development journey. Photos which you display, the legal basis is more than likely consent, because these photos are not required and they're not necessary for you to do your job. They're nice and it's lovely for the children to see their picture on a birthday display, but it's not a legal requirement. You don't need to have them on the wall. Sharing photos with parents, the legal basis might well be legitimate interest, because the EYFS requires us to share information with parents to support children's home learning and to let parents know what their children are doing with us. However, if you put photos of children online, you must use the legal basis of consent first. and parents must be told exactly what you're doing with them and why. Parents can refuse, and if you're asked to delete them, ICO state you must take measures to do that. When we're thinking about photos to advertise the setting, the legal basis again is consent, because you can, for example, take advertising photos without including children in them. There's no requirement specifically to have a child in that photo. And when we're thinking about nice photos, group photos, again, the legal basis is consent, because you don't need to take those photos to do your job. They're not needed for any legal purpose. If your legal basis is legitimate interest, so if you're taking photos to record learning and development, and or you're taking photos to share with parents, then you need to think about doing a legitimate interests assessment, a very quick process, a 3-part test, ICO describe it as, to identify your legitimate interest. For example, these photos are taken to promote children's learning. Children look back at the photos and talk about them. The photos are shared with parents. You must then show that the processing is necessary to achieve it. For example, you might argue that the children's learning and development files would not demonstrate the child's progress effectively without photos of them at different ages and stages and doing different things. And then ICO state that you must balance this against individual interests, rights and freedoms. Do you remember those from the very beginning? For example, you might say, parents might reasonably expect you to process photos of their child for the purposes of recording learning and development. And of course, the processing doesn't harm the child. ICO advice is that you keep a record of your legitimate interests assessment to help you justify your decision and to help you demonstrate compliance with GDPR. There's more information about the 3-part test on the ICO website and in the handout that comes alongside this presentation. If parents argue that you don't have a legitimate interest to take photos of their child, and they are perfectly within their rights to do that, you'll need to consider whether you can justify your decision or not. You'd probably in this instance need to stop taking photos and either take further advice from ICO or find another way of showing the child's progress and sharing information with parents. Of course, you can continue to use the legal basis of consent as detailed in the permission form from Childcare.co.uk for all your photos. That is completely up to you. But that's why I've put it as a separate photo permission form so that you can tweak it if you want to. I want to go through some frequently asked questions. I know this is a lot of information to process. That's why it's in a video, so you can come back to it. And this is why I'm sharing my notes exactly as I've written them and exactly as I'm speaking them. So you can come back and you can look at different sections again. However, I am getting asked a lot of questions about photos. So I thought if we did a quick question and answer, it might just mop up a few concerns. I've been asked this one a lot. What about the rights of the child, Sarah, in all of this? Because obviously we're talking about parents and parental responsibility. Parents sign to say we can use their child's photos, or not, as the case may be. GDPR strengthens the rights of the child. It's actually got a section about children's rights in it. Parents must have parental responsibility to act on their child's behalf, and GDPR states that we must make reasonable efforts, and I'm putting that in speech marks because that's a quote, reasonable efforts to check that the person who's signing does have parental responsibility. So we need to think about how we're going to do that. If a child objects to having their photo taken, it's important we show them respect and allow them their right to choose. Once they start understanding about social media, for example, and email and text and all of this, we also need to have a conversation with them and check they're happy for us to put their photos and other information about them online. When we're thinking about parents withdrawing consent for us to process data about their children, we need to think about two different things. If parents withdraw consent for us to process photos, we will need to delete all the photos. Stop processing, stop taking them, remove them, delete them, hand them over if they're printed, or shred them if parents don't want them. This would possibly be in a case where there's been a catastrophic breakdown in our relationship with parents, and everything has to go. If a child's featured on a group photo and parents withdraw consent, you need to take measures to delete it. You should also then be asking other parents who may have seen the photo and got the photo to delete it as well. If ICO are called in to investigate, and this is the important thing, they will make a decision based on your legal basis for processing, other documentation explaining how long you keep photos, what you do with photos, for example, your retention policy, and how hard you've tried to stop those photos still being used. If a parent withdraws consent for other types of data processing, we're thinking here about, for example, accident and medication forms. They can't do that because they're covered by other law. They're covered by the Limitation Act 1980, which states that we must keep hold of them. Here I'm talking specifically about photos. You're very unlikely to have a legal basis for holding on to them, for retaining them. When you're thinking about taking photos to share with other agencies or professionals, it depends on why you're taking them and what you're going to be doing with them, and what will happen to them when they're handed over. For example, I know some providers put a photo of a child with the child's 2-year progress check, and that's maybe a nice thing to do, and then that's given to the health visitor. This is where it will be important to have a data sharing agreement with parents, so they know exactly what's happening to the photo, to the data, and where it will go and how it will be used. There's nothing to stop you sharing photos with consent from parents, but you will need to consider the efforts you have to make to delete them should parents withdraw their consent. When a child leaves and you're handing over their learning journey, that will contain the photos you've taken with their child in. You should remove all other photos held for business purposes from your files, unless you have consent from parents in writing to keep them. Remember, consent is the weakest of the legal bases because it can be withdrawn at any time, and you must inform parents that they can withdraw it. This type of processing should be detailed in your retention policy. That's why I've written one for Childcare.co.uk free files, because ICO talk about retention policies a lot. It should be shared with parents when they first start in your care, but it can be 4 or 5 years, can't it, before they leave, sometimes longer, which is why I've also included information in my updated contract termination letter. There's no requirement to give parents a contract termination letter, but should you decide it's a good idea to do it, it's written for you, hand it over, signed and dated, and it also repeats data retention law. Data retention information. So you can share that again with parents. You can remind them what happens to their child's data, to their data, when their child leaves. This is a question I'm asked a lot. Sarah, what if it's a photo of my children and child-minded children? What then? I want to keep that because that's my children's memories. ICO advice is that if photos are held for domestic purposes, for example, your children are in the same photo as a child-minded child, then you can argue that this is not the same as photos held for business purposes. If you keep these photos, these domestic photos of your children and child-minded children, you will need to, if challenged, be able to justify why you're keeping them. And it would be helpful if you've discussed what you're doing and why with parents and recorded this in writing. And that 3-part questionnaire we did a few minutes ago can be used for this as well. Why have I got them? What am I doing with them? How long am I keeping them? Have I got a fair, transparent, reasonable reason for retaining those photos? And if you say yes, you believe yes, then that's fine. If you need to justify it to ICO at any time in the future, that's fine. And if they disagree with you, well, you delete them. This is a screenshot from the ICO website, and it's about the right of erasure. This refers to us, don't forget as well. We have a right to erasure of our data when it's held in other places. And over the next few months, you'll be getting all sorts of emails from places that hold your email address and other data about you saying, we need to check that you've opted in. And on the permission form that I've updated for Childcare.co.uk, you will notice there is an opt-in option now. Parents have to tick as well as sign. You know those boxes we used to sign that were so complicated you'd read them 3 times before you tick because you weren't sure whether you were opting in or out or around the garden? Those have to go. It has to be a clear opt-in or opt-out. So if a parent opts out, if a parent withdraws permission for you to hold data about their child, or if an older child says, I don't want you to hold that anymore, again, we need to consider what's our legal basis for holding on to it. You can't hold on to things just in case. You need an appropriate reason for data retention, and it should be stated in your retention policy already, so it's clearly written down, and that's dated, and that's been given to parents, and parents have signed to say, yes, we've seen all your policies and procedures, and we've read them, and we understand them. I put all mine into PDF and email them out. Parents then can read them at their leisure. For example, if data is required by the Limitation Act, then you'll need to keep it until the child is 21 years, 3 months old. And that's law. Right to erasure does not work in this instance because it's law. If it's required by the early years foundation stage, that states it must be retained for a reasonable period of time. And that's a quote, so I'm putting in speech marks. ICO suggests you might consider reasonable to mean between offset inspections or for the period of an inspection cycle. It's for you to decide and justify and share with parents in your retention policy. Don't forget, my examples are exactly that. They're examples. They're for you to consider how you want to use them. ICO state that we should have a written retention policy, which is why I've written one and I've put it on the Childcare.co.uk website. It's completely up to you whether you use it. It will help you to comply with the principles of GDPR. You're informing parents about the purpose of processing data, the retention period, and their rights. Their right to be forgotten, their right to erasure. You'll need to share your retention policy with current parents. GDPR isn't retrospective, but you'll need to let current parents know that on May the 25th there's a new law coming up, and you'll need to show them your retention policy, show them your new privacy notice, and say, I've done a data audit. It's here if you want to see it. I've risk assessed how I'm keeping data safe. I've thought about what will happen if there's a data breach. I've got all the documentation here if you want to see it. Up to you. Your retention policy will help you to ensure you're compliant with the rights of individuals and that you're being transparent about the data you hold. Remember, back at the beginning we said transparency is a key requirement of GDPR. Look out for more information about GDPR. I'm sure lots of other companies will be releasing their information as well. At Childcare.co.uk, they've tried very hard to ensure everything is accurate and everything is shared in a timely way. You have 2 months to change this and get it right on the date this was recorded. If you've any other questions about GDPR and photos, you can contact the Information Commissioner's Office by email, although I believe emails are taking some time to be replied, or by phone, whichever you find easiest. And you will find retention policy and other GDPR documents on the childcare.co.uk website, which you can adapt for your purposes. Thank you.